Chapter 1. The Child Support Problem in America. Introduction. In 1984, Congress enacted Public Law, P.L. 98-378, better known as the Child Support Enforcement Amendments. This is by far the most significant step taken by the federal government in child support enforcement since Congress enacted P.L. 93-647 in 1975 to establish Title IV.D of the Social Security Act, thereby creating the Child Support Enforcement Program. Both the 1975 implementing legislation and the 1984 amendments were inspired by dramatic changes in our social structure, the growing instability of marital relationships, the feminization of poverty, and increases in out-of-wedlock births, especially among teenagers. As a result, more and more children are living in single-parent families. In single-parent households, financial contributions from absent parents often fail to constitute a significant portion of the family income. In fact, almost 9 out of every 10 children who are receiving welfare through aid to families with dependent children, AFDC, have a living parent absent from the home. This chapter discusses the child support problem in greater detail, identifies its effects on society at large and the legal system in particular, and assesses the effectiveness of the Child Support Enforcement Program as it completes its first decade. Subsequent chapters discuss federal and state program roles and responsibilities and detail the role of the judiciary in the child support enforcement effort. The remainder of the guide concentrates on the process of establishing and enforcing child support obligations. Causes of the child support problem. The child support enforcement caseload has grown in response to a host of complex demographic, economic, and sociological factors. The following pages discuss recent developments that have affected the child support problem in America and forced families to seek AFDC benefits. These developments are increased rates of divorce and desertion, households headed by single females, and out-of-wedlock births. Divorce. In the last several decades, divorce rates have increased dramatically. Between 1963 and 1975, the national divorce rate increased 100% and then increased 100% in each year thereafter until 1981. In 1981, the number of annual divorces climbed to a record 1.2 million. It is further estimated that 49% of all existing marriages will end in divorce. Desertion. The dimensions of the non-support problem become even more staggering when one considers the vast numbers of couples who simply separate without obtaining a divorce. In 1960, the number of separated individuals heading a household in which children reside was approximately 1,058,000. By 1983, the number had increased to over 1,917,000, which is an 83% increase. Of this 1983 figure, approximately 1.8 million families were headed by women. An important aspect of marital disruption is the impact on children. Studies have revealed that today there is a greater chance than ever before that a couple will have children at the time of a divorce or separation. In 1983, 21.8% of children under 18 lived with only one parent, 19.4% with the mother, 2.4% with the father. This is a 107% increase from 1970. The Census Bureau estimates that nearly half of the children born during 1982 will spend a significant portion of their lives in a single-parent family. Out-of-wedlock birth rates. By far the most significant rate of increase in single-parent households has occurred among never-married mothers. Between 1970 and 1983, the number of never-married mothers increased by 377%. By 1983, 1/4 of all single parents were in this category. Of the 7.6 million women heading single-parent families in 1984, 2.1 million had never been married. Of particular concern is the rate of out-of-wedlock births among teenagers. In 1981, 537,024 children were born to teenage mothers, and about 1/2 of these babies were born out of wedlock. Effects of the child support problem. These changes in the social structure of the United States, coupled with the lack of an accessible and effective process for ensuring that both parents contribute to the support of their offspring, produced at least 3 significant effects. First, A greater proportion of women who have children are finding themselves living below the poverty line, a phenomenon that has been termed the feminization of poverty. Second, welfare expenditures to support dependent children continue to rise during a period in which federal, state, and local revenues are hard-pressed to meet taxpayers' expectations for other necessary governmental services. Third, parents who fail to pay or receive child support lose respect for the legal system, which often has lacked the authority, will, and resources to provide effective remedies. The feminization of poverty. A growing number of single mothers are heading their own households. In 1984, there were 33 million families with children under 18 in the home, and 7.7 million were one-parent households headed by women. This figure represents a 13.2% increase since 1980, and a 100% increase since 1970. As a consequence, increasing proportions of families are headed by women with sole responsibility for raising and caring for children. Since the probability that a woman will become a widow has not changed substantially, the increase in female-headed households can be attributed directly to the rising divorce and, out-of-wedlock, birth rates. This situation is economically as well as sociologically significant because the absence of a parent usually means a lower standard of living for the family. In 1983, the poverty rate for the nation, determined on an income per family basis, was 15.2%. The rate was 40% for single-parent families headed by white women and 75% for those headed by black women. The composite poverty rate for all families headed by females with no husband present was more than 3 times that for married, couple families. In short, society is faced with an increasing number of dependent children in female-headed households with marginal incomes. These women, left alone to care for the children, frequently cannot cope adequately on their own. It is difficult to both care for children and work. Those who do work usually cannot command a sufficient salary to meet the needs of their families. Without financial support from absent fathers, mothers very often are forced to seek public assistance. As of March 1984, median incomes for female heads of households were as follows: married, absent husband, $8,851, widowed, $8,806, divorced, $13,486, never married, $13,251. According to the 1981 survey on child support and alimony conducted by the U.S. Department of Health and Human Services, DHHS, and the Department of Commerce, of the 8.4 million women living with a child under 21 years of age whose father was not living in the household, 59% were awarded child support. However, of the 4 million women due child support payments in 1981, only 47% received the full amount, 25% received partial payments, and 28% received nothing. Consequently, the problem of increasing welfare costs in the United States is, to a considerable extent, a problem of the non-support of children by their absent parents. Increasing welfare expenditures. Until the 1930s, government involvement in the support of dependent children was virtually non-existent, except for the imposition of criminal remedies for non-support. However, because of the Depression, by 1933 many people were in need of public assistance. Approximately 2.5 years later, on August 14, 1935, Congress passed the Social Security Act, which was signed by President Franklin D. Roosevelt on the same day. The act was the first attempt at providing social insurance in our country. The original act contained no comprehensive system of social insurance, and it was amended throughout the years to include many categories of need. In an early amendment, Title IV, of the Act, Aid to Dependent Children, now Aid to Families with Dependent Children, AFDC, the federal government assumed some responsibility for the support of needy dependent children. The AFDC program encourages the care of dependent children in their own homes or in the homes of relatives by enabling each state to furnish financial assistance and rehabilitation to needy dependent children and the parents or relatives with whom the children reside. The AFDC program was created to help maintain and strengthen family life by providing financial assistance to custodial relatives in addition to the children. children can continue to be protected and cared for by their parents. Government spending on all social welfare programs increased rapidly over the years, from $77 billion in 1965 to over $286 billion in 1975, almost a fourfold increase in a single decade. Eventually, taxpayers began to demand reduced government spending, and Congress began to examine welfare programs for possible budget cuts or changes that could make the system more effective. The rest of this section discusses the congressional study of and response to the AFDC program because of its special relationship to the non-support problem. The size of the child support problem in the United States was difficult to analyze until recently because there was little data on the subject. However, it has become clear that the number of families receiving AFDC has a direct relationship to the problem of non-support. Figures on the AFDC program show a steady increase in both AFDC recipients and associated costs. Since the beginning of the program, there has been a gradual upward trend in AFDC caseloads. The number of children receiving AFDC first doubled from June 1948 to February 1960 and then doubled again in less than 9 years from February 1960 to January 1969. 12 years later, in March 1981, the number of children receiving AFDC had increased another 77% to 7.7 million. Even more significant is the increase in the proportion of children under age 18 receiving AFDC. In 1948, 25 children per 1,000 under age 18 in the United States were receiving AFDC. By December 1966, 18 years later, the number of these AFDC children had doubled in relation to the total number of children. It then doubled again in less than 4 years, from December 1966 to June 1971. By 1973, there were 113 AFDC children per 1,000 under age 18 in the United States. In other words, 11.3% of the children under age 18 in the United States were receiving AFDC in 1973. This is compared to only 2.5% in 1948. The costs associated with these increases have continued to be enormous. For example, between calendar years 1960 and 1983, the cost of AFDC money payments increased from $1.0 billion to $13.8 billion. Investigation of this dramatic increase in the AFDC rolls shows a drastic change in the nature of the AFDC recipients nationwide since the program began in 1935. Initially, death of the father was the main basis for eligibility. Since World War II, the reason increasingly has become the absence of the father from the home. This figure has risen from 45% of the AFDC cases in 1948 to 88% in 1983. An overburdened legal system. When Congress created the Child Support Enforcement Program in 1975, it delegated to each state legislature the authority to decide on the structure of the program within each state, the resources committed to the task, and the legal procedures and remedies available to the program. State legislatures responded by enacting implementing legislation that authorized the creation of new agencies at the state or local level to locate absent parents and prepare cases for stipulation or litigation. Legislators apparently assumed that existing court procedures and resources would be sufficient to handle the volume of cases to be processed. Often, this assumption proved incorrect. Backlogs have occurred, both in program attorneys' offices and in the courts. Many courts have lacked sufficient personnel to handle the scheduling, hearing, and processing of cases. Competition from juvenile court and child abuse caseloads has made court time a precious commodity. Remedies have been inadequate to enforce compliance with existing support orders or too cumbersome to allow for expeditious and efficient case processing. In addition to exacerbating the non-support problem, these insufficiencies have caused a significant proportion of the populace to lose confidence in and even respect for the legal system. As divorce and out-of-wedlock birth rates have risen, Many individuals who have never been exposed to the legal system have become involved in divorce proceedings and paternity suits. These parents' sole experience with the legal system has been to witness its difficulty in resolving these disputes and its inability to enforce a resolution once entered. Such experiences take a toll in public confidence and respect. The Child Support Enforcement Program. The negative effects of the child support problem discussed above helped promote the enactment of strong legislation at the federal level. In particular, Congress created the Child Support Enforcement Program. The program, Title 4D of the Social Security Act, Part B of PL 93-647, was signed into law in 1975. As noted in Appendix A at the end of this guide, Congress has acted in almost every legislative session since that year to improve or expand the program. The program is charged with locating absent parents, establishing paternity, and obtaining and enforcing support owed by absent parents to their children. The federal legislation places responsibility for the Child Support Enforcement Program at both the federal and state levels, giving the DHHS, Office of Child Support Enforcement, OACS, primary administrative, regulatory, and technical assistance responsibilities and delegating to state 4D agencies the operational aspects of the program. With the Child Support Enforcement Amendments of 1984, Congress set forth more specific requirements as to how these state and local operations are to be carried out. Most of these requirements, which are discussed in detail in subsequent chapters, are based on successful practices in effect in one or more states. Even though the Child Support Enforcement Program centers on the enforcement and collection of child support, the program benefits the taxpayer, the child, and the legal system. The taxpayer. The millions of dollars that the Child Support Enforcement Program collects each year represent a direct benefit to taxpayers as well as to children and families. In fact, the program is one of few government programs that helps needy families while also saving tax dollars. As of October 1, 1985, the federal government matches 70% of costs incurred by states in the administration of the program. The rates will be reduced to 68% on October 1, 1987, and again to 66% on October 1, 1989. 17 matches 90% for costs related to the development of management information systems, and permits the states to retain as much as 50% of support monies collected to offset the state costs of AFDC. As an added incentive to operate effective programs, states and localities involved in the collection and enforcement of child support are entitled to an amount ranging from 6 to 10% of both AFDC and non-AFDC collections. These incentive payments may be used for whatever purposes governing officials deem appropriate. In addition to its direct revenue-generating aspects, the Child Support Enforcement Program produces indirect financial benefits through the provision of services to non-AFDC families who, without income from child support, might be forced to turn to public assistance. Similarly, through program efforts, sufficient support is collected on behalf of some AFDC families to eliminate their dependence on welfare and related assistance programs. The child. Although its primary role is a financial one, the Child Support Enforcement Program clearly offers social, economic, and medical benefits to children and fosters in families a sense of parental responsibility, heritage, and self-esteem. Establishing paternity for a child born out of wedlock and having that parent contribute financial assistance for the child's upbringing, that otherwise might come from public funds, benefits society and the child. In addition to providing an alternative source of income for the family, absent parents may be able to provide their children with access to such social entitlements as Social Security benefits, pension benefits, veterans benefits, and other rights of inheritance. The children also gain social and psychological advantages from having legally identified parents and a sense of family heritage. Perhaps the most important of these advantages is escaping the prejudices often held against children who cannot identify their fathers. A legally established relationship is a first step in creating a psychological and social bond between a father and his child. Further, it is in the child's best medical interest to know who his or her parents are. A significant number of diseases, illnesses, birth defects, and other abnormalities are passed to children by their parents. This knowledge of medical history is the only way of predicting a child's susceptibility to some medical disorder before it occurs. The legal system, as the focal point of the child support enforcement program and the upholder of strong public policy interests in protecting the rights of children and their parents. The legal system can derive certain benefits by becoming familiar with and more involved in state and local child support enforcement programs. First, rapid enforcement of support orders conditions the absent parent to avoid the inconvenience of a court appearance by making regular child support payments. Second, improved handling of child support cases will increase respect for judicial decrees and orders and increase community support for the program. Third, federal financial participation is available for certain judicial staff and operational costs through the state 4D agency, when properly documented. Finally, the legal system has the fundamental responsibility to ensure that the rights of all parties, the state, the child, the parents, and the taxpayers, are protected. The system can carry out this task more easily and effectively when the judiciary is well informed about all legal aspects and the administrative ramifications of the Child Support Enforcement Program. Current status of the Child Support Enforcement Program. The Child Support Enforcement Program can point to significant achievements. These include the development of a federal organizational and operational capability through OAKS to support state 4D programs, the building of a comprehensive policy and regulatory base, and the provision of high-quality services and products to states and jurisdictions operating the 4D program. Clearly, the best measure of the Child Support Enforcement Program's nationwide effectiveness during its brief history is the steady growth in collections. Present AFDC collections more than quadruple the amount collected in 1975. From federal fiscal year, FY 76 through FY 84, more than $13.2 billion in child support payments have been collected, $5.7 billion of that amount on behalf of families receiving AFDC. The total amounts collected each year have increased steadily from $500 million in FY 76 to $2.4 billion in FY 84. In the same period of time, the paternity of over 1.2 million children was established. Legally enforceable support orders were established in about 3.3 million cases. In addition, from FY 80 to FY 84, nearly 4 million absent parents were located. These achievements have been realized while actually saving or making money for state and local governments. For example, in FY 84, for every dollar spent on 4D operating expenses, $1.38 was collected on behalf of AFDC families and used to reimburse state and local governments, and $1.91 was collected per dollar on behalf of non-AFDC families. This cost-effective operation, combined with incentive payments from the federal government, provided over $350 million in revenue to state and local treasuries during the year. Notwithstanding these favorable trends in collection growth and despite its achievements, OAKS is concerned with the rate of progress of state and local 4D agencies in operating more cost-effective programs. Collections made on behalf of children have increased at a slower rate in recent years. At the same time, program expenditures are increasing steadily. If this trend continues, the overall program eventually will cease to be cost-effective. The performance of the best state programs clearly indicates the vast potential for nationwide improvement. See Exhibit 1.1. During FY 84, the average of the 10 best states' performances in recovering AFDC payments in a number of categories was dramatically superior to that of the nation as a whole. For example, the 10 best states recovered AFDC payments at a rate more than twice the national average. They also collected child support on behalf of AFDC recipients from a percentage of absent parents that was about 2 1/4 times the national average. The states with the most cost-effective programs, ratio of AFDC collections to administrative costs, were almost twice as cost-effective as the other states. Finally, the ratio of non-AFDC collections to total administrative cost for the 10 best performing states was over 2 1/2 times the national average. In contrast, The 10 worst performing states recovered AFDC payments at a rate that was slightly over one-half the national average. They collected support from a percentage of AFDC absent parents that was one-third of the national average. The cost-effectiveness ratio of the programs in the 10 worst performing states was just over one-half that of the national average. Further, the ratio of non-AFDC collections to total administrative cost for the 10 worst performing states was only 8% of the national average. If one compares the 10 top performing states with the 10 lowest performing states, the contrast is even more astounding. Of particular significance is the wide diversity of performance among states and localities. The ability of some states to operate highly effective programs shows that there is great potential for all states to generate additional revenue. Exhibit 1.2 provides a state-by-state review of both AFDC and non-AFDC cost-effectiveness ratios for FY84. Examining these discrepancies in performance shows that the potential for recovering additional revenue is staggering. If all of the states currently performing below the national average increased their cost-effectiveness to the national average, the additional welfare savings for the taxpayer would be almost $300 million per year. If the program as a whole could recoup 25% of the AFDC costs, it would be collecting more than 4 times what it now collects. Current collection and administrative expenditure growth trends suggest that program performance can be improved while administrative costs are contained. The U.S. Bureau of the Census estimates that over $3 billion in unpaid child support obligations exist yearly nationwide. Without affirmative judicial involvement and the effective operation of the child support enforcement program at the federal, state, and local levels, the rights of children to receive support from both parents and to enjoy the benefits of having their paternity established are thwarted. Future directions. As noted at the outset of this chapter, the Child Support Enforcement Amendments of 1984 reflect a clear congressional mandate to force states and local jurisdictions to adopt improved procedures, management practices, and legal remedies. These mandatory changes, which are discussed throughout the remainder of this guide, will radically alter the structure of the child support enforcement programs in many states. The role played by the judiciary likewise will change drastically as many states implement expedited judicial and administrative processes for child support, as discussed below in Chapter 4. As noted in Chapter 5, support obligations established pursuant to new mandatory procedures should be entered more expeditiously and should be based on objective standards. As noted in Chapter 8, more effective enforcement remedies are to be applied more consistently to a greatly expanded number of delinquent cases. Of particular note is the legislative provision for mandatory income withholding for all cases when the delinquency equals the amount of 1 month's obligation. Interstate establishment and enforcement will improve as a result of the interstate income withholding procedure mandated by Congress, and OAKS's commitment to improvement in this crucial area. These changes are discussed in Chapter 10. By mandating expedited processes for establishment and enforcement of support obligations, Congress has issued an invitation to the American judiciary to become involved in implementing, administering, and improving the child support enforcement process.